Hello and welcome to Renegade Report. Roman is present. Unfortunately, Jonathan is not. He is still working at the moment because it is a weekday, but he will join us on the next one, so not to worry. We are live from Vodcast TV in Rosebank Mall. If you want to know more about them, check the link in the description below. So we have a very special guest today, one that I've been wanting to have on the show for over a year, I believe. And he's finally here in Johannesburg. Professor Koos Malan, welcome, sir.
Thank you, Roman. It's very nice to be here. Thank you very much for the kind invitation. I sincerely appreciate it.
Oh, well, I mean, you crossed the Boerewors curtain on the way down here from Pretoria. So, I mean, my thanks extends to you. You did the hard work. I'll just sit here and talk to you for an hour, which is easy.
Traffic was not that bad today.
Okay. Small mercies. So, Professor, I read your biography, and it says that you were a prosecutor, a magistrate, and now you're a professor of law since 2007. Why isn't a prosecutor quite fun? Why would you want to move away from that?
Well, one of the first stepping stones within the legal sector for many people, especially in the days when I studied law, when I finished my law degree, finished the B Juris in those days, was to begin as a prosecutor. One of the benefits of being a prosecutor is that you learn how to deal with witnesses. Now, the moment one utters the word how to deal with witnesses, it might sound quite aggressive in that it suggests only cross-examination. But what I mean by that is simply that you learn how to lead evidence, how to adduce evidence, and then also how to cross-examine. And specifically when it comes to litigation, that's, I won't say the beginning and the end of everything, but it's close to that because, one is normally under the incorrect impression that it's only a question of law, whilst mostly in litigation it's factual questions that are important, and the factual questions are to a large extent determined through evidence and proper examination, also proper cross-examination. So that's why I actually began as a prosecutor and later on a magistrate, yeah.
All right. And you've been a professor since 2007, I believe?
Since 2007, but I've been involved in university education now for 20 years to be exact.
Right. And it says here, and this may be incorrect or correct, your interests as a professor is constitutional theory, democracy, minority questions, and language law.
That's to a large extent correct. Even though at first glance those issues might seem not to be related, they are in fact related. The question of constitutional theory actually should be emphasized, because if you find a constitutional jurist, the professor will tell you that he's first and foremostly interested in constitutional law. Now, obviously, I am interested in constitutional law, but you can't develop a proper understanding of constitutional law unless you have a proper understanding of the background, of the bedrock of constitutional law, which is constitutional theory, which on its part is related very closely to politics. As a matter of fact, I think it's actually to a large extent impossible to be a proper lecturer of constitutional law if you do not have a proper grasp of politics. In the United States, at some of the universities, for example, specifically at Yale, I know two senior law professors there, and they're actually professors of political science and constitutional law, which conveys a very important point, and that is the truism that one has to grasp that interlinked relationship between the two. If not, if you don't have a proper grasp of politics as the background reality within which constitutional law takes shape, then I think in the final analysis you're a babe in the woods when it comes to constitutional law.
You're making quite a dangerous statement there, because I've heard, being a law graduate myself, that the constitutions of the world need to be stable, objective, truthful, and shouldn't be in abeyance to the political theory of the time. Are you saying that's false? Are you saying my education has been based on a false premise, Professor?
Let me rather not express any view on your education, because perhaps you might be making a misrepresentation as to your education. Let me put it this way.
Sure.
I think it's a general misconception of liberal constitutionalism, liberal constitutional law, and a liberal constitution, which I actually call statist-individualist constitutionalism, to view a constitution in that particular way. In other words, something which is in a sense distant from and insulated from politics, where you have a kind of an objective truth, where constitutional provisions are properly formulated, and where you have a so-called independent and impartial court, specifically Supreme Court, the highest court, the Constitutional Court, which serve as the guardian of the Constitution and whom can be trusted on to tell us what the actual true meanings of constitutional provisions are. Now, that is blatantly wrong, and I think it can also be indicated with reference to the South African experience of the last 10, 15 years, how far distance that actually is from reality.
That's a bold statement, Professor, but I'm not surprised, because thankfully you kindly offered me your book late last year. If you're on YouTube, you can see it now. It is called There Is No Supreme Constitution. Good title, by the way. And you've explained quite well throughout the book why the title makes sense. So let's go back to your definition, the so-called Statist-Individualist Constitution. So I understand those two words separately: statist, a state; individuals, well, an individual person. What do you mean by all three together? Statist, individualism, constitution. What are the parameters of that definition?
Yeah, okay, that's a good question, and actually precisely the appropriate point to start off with. As Westerners, as people belonging to Western civilization, which I strongly subscribe to, the idea of constitutionalism actually lies at the very root of our political thinking, of our thinking of how a public order should be organized. The first prerequisite of the idea of constitutionalism, the conditio sine qua non of constitutionalism, is the need to strive towards the achievement and maintenance of justice. Now, that is obviously very difficult to achieve and very difficult to maintain. But that should serve as the lodestar and as the criterion throughout whenever the idea of constitutionalism is under discussion, the idea of justice. As a matter of fact, one can go back to the Corpus Juris Civilis, the Roman Corpus Juris Civilis, that was written back in the years 527 up to 565, which is basically a codification of Roman law up to that time. Now, one of the very first things that you find in the Corpus Juris Civilis is an assertion by Celsius, a well-known Roman lawyer, who precisely demonstrated the point that that is what law is primarily about, the achievement of justice. And what one can then say about constitutionalism is exactly the same. But constitutionalism represents the ideal of justice on a broad scale for the entire community,
right?
On a systemic basis. That's the first thing. The second thing is the idea of the rule of law. Now, when nowadays we speak of the rule of law, it has a kind of a technical meaning, simply referring to, well, there's the law is mostly written down, and see to it that the law is adhered to. Now, that's fine, but that's not where it stops. The whole point about the rule of law is that the rule of law is based upon a communal consensus. That's actually very important. Very often we tend to think, and that involves the individualist side of your question, we think about law as simply the product of a social contract based upon a number of individuals, any number of people, as John Locke would have said, that have come together and that have entered into a contract and say, okay, from now on, we'll adhere to this, to the following set of legal norms. But that is actually very superficial. In a sense, you can only have a proper system of rule of law if there's a communal basis for it, if there's some strong basis of cultural commonality among the people who are involved in a legal system, and who form the legal system, who constitute the legal system, and who almost, and that's very important, automatically adhere to the law, which they regard as actually part of their communal character. So in other words, you do not need some institution from outside to impose the law. That happens only in the exceptional cases where the law is not adhered to. But the rule of law in itself is based upon a rootedness in communal consensus.
So your argument is that law is an emergent social order.
Yeah.
So there are norms that happen over decades or centuries, and sooner or later those norms become codified, but in a way that is from the grassroots up, rather than the state taking over from the top down.
Yeah.
So you're creating a natural hierarchy from the bottom.
Yes, exactly.
Yeah,
exactly.
I think that's a perfectly valid argument.
I think that's the appropriate way to look at the phenomenon of constitutionalism and the phenomenon of a constitution. In contrast to the way that we, for example, in South Africa would have been inclined to look at it, namely as some almost religious-like document that has been written by a number of people and that is almost kind of imposed upon just a number of people, even though there's a lack of communal consensus.
Right. Well, I mean, the libertarians, the famous line from the libertarians is, I didn't sign any social contract. Show me where I signed the social contract because I didn't do it. And that is, it's funny, but it's also fair in some ways because law is imposed on us as citizens of the country because we are citizens of the country. But being a citizen has no real definition anymore other than the mechanical way of having a passport or something like that, or you happen to be born here, or you live in a geographical area. But it doesn't. Why would the state want to impose the Constitution upon us, drawn up by the way, elites?
Yeah.
I mean, I was here at the time. I didn't have any input. You were here. I don't know if you had any input in the Constitution, but I mean, I didn't have any input. So why must I abide by the laws imposed on me?
No, actually, I think you are touching upon something which is very important. In the first instance, this whole question of the social contract, if one goes into the social contract theory of Hobbes and of Locke and so on, and many other people, but those two theorists are perhaps the most important people when it comes to social contract theory. The reason why that theory was developed is because it was assumed that the natural state of mankind, natural state is that there is no such thing as a community. And that you can only form a community on the basis of a kind of an artificial contract being entered into by any number of people. That I think is wrong. I think communities are a basic ingredient of society. And one of the characteristics of a community is specifically that community has already a sense of belonging, has already a number of rules, even though those rules are not specifically articulated, that they adhere to. So they are in a legal system even without explicitly realizing it.
Right. I mean, have you read Yoram Hozoni? He wrote a book called The Virtue of Nationalism.
You know what? I happen to have read it, yes.
Oh, really?
Yes.
Okay, so he has a great 2 or 3 chapters on Enlightenment thinkers.
Yeah.
And he says these people made proclamations on people just like them, but they made it for the entire world. So if you look at most of the Enlightenment thinkers around the social contract and individual human rights, these were people with no children. They were ostracized from their communities, and they thought they were reasonable and rational. And they assumed that everyone else in the world was the same as them. So the Enlightenment ideals are not at all universal. They were just applicable to those few thinkers, and they applied them to the world generally as such. And that was a very powerful argument, because I was quite an Enlightenment type thinker. It's obvious. Individual human rights, freedom of speech. These are all very important things as self-actualized individuals. But that book and your book made me realize that that whole premise is not founded on any firm ground whatsoever.
No, it's a theory in the air almost. In a previous book, sorry for being so presumptuous to refer to that, Politocracy, with a subtitle, specifically in chapter 4 of the book, I actually discussed those theorists. And the point argued basically boils down to, I think, largely the same as Arzoni's argument. I was obviously very glad to read that, especially coming across the very forceful formulations of the young man. He's still a young writer. But I fully agree with him as far as that is concerned. Yes.
All right. So very good. So we are slowly going to destroy the Constitution little by little during the course of this conversation.
Actually, there's no need for that. It's already
it doesn't exist
in
anyway,
an advanced state of destruction.
So, I mean, let's just take the basic thing. So if I listen to Professor Pieter Vos from Cape Town, right? This man thinks that the Constitution is the 10 Commandments, and if you go against the Constitution, you sin. And because it's in the Constitution, you have to abide by it. So dignity is vitally important, human dignity. Free speech can be regulated because the Constitution said so. He gives a lot of reasons why human behavior should be regulated according to the Constitution. And based on his mindset and the paradigm in which he lives, it makes sense. But obviously you would disagree with all of those presumptions. And most importantly, what does the Constitution as it stands right now mean to you as a professor of law?
Well, look, in the first instance, those things that you've mentioned, the right to dignity, freedom of expression, and so on, those are things that are very important to me. As a matter of fact, as we are sitting here, we are exercising those rights, and
Absolutely.
Through the way in which we're also expressing opinions, even though it might to a lesser or larger extent be controversial, we actually also take into account the dignity of other people. But why do we do so? Because the Constitution allows us to do so? Because it's imposed upon us? No. Because we share a particular communal morality, and our conduct is a conduct of a content as a result of that. The very basic mistake I think that is being made by many theorists, and a mistake that I, as far as possible, try to guard against, is the following: is to simply swallow the most important articles of faith of modern statist-individualist constitutionalism. Firstly, that the Constitution is supreme, and that the Constitution can only change through amendment, that is on the basis of a two-thirds majority of the National Assembly in Cape Town and 6 of the 9 delegations of the National Council of Provinces. That is wrong, and we can go into that. The second article of faith is that the Constitutional Court and the other courts are also independent and more specifically impartial courts, and consequently we can invest all the trust that we have in them to be the guardians of our rights. And thirdly, that individual rights, and that might be a controversial point, but it's a very important point to argue actually, that individual rights that if you have a full catalogue of individual rights, that actually exhausts all forms of legal protection. That is wrong, because one of the fundamental prerequisites of constitutionalism is a system of checks and balances. Now, the moment you refer to checks and balances within the present South African framework, the first thing that comes to mind is the legislature, the executive, and the courts. And it is assumed, without any questioning of it, that they in fact do represent three distinctive sources of power, and that they keep each other in check. and that most notably the Constitutional Court plays the primary role in that. And the way in which they played that role is by interpreting individual rights and in that way protect the people claiming those rights. Now, in those assumptions, there are two fundamental mistakes. Firstly, the Constitutional Court, the courts generally in South Africa, together with the African National Congress, which is dominant in the legislature and obviously in the executive, constitute one and the same power apparatus, one and the same power elite, assuming with the same ideological assumptions and seeking to achieve the same ideological ends, which in South Africa at the moment, you can call many names. I prefer to call it transformationism. We can go into that. And that is basically a fairly far leftist ideology of achieving cultural homogeneity and achieving a socialist state on the basis that prehistorically that was the condition. So it's almost, dreaming up kind of a romantic situation that was once into existence and thinking of the Constitution through constitutional values, through individual rights, and through the Constitutional Court to help to achieve that. So, in other words, the first point is that to think of the Constitutional Court as a true check and balance upon the ANC is actually wrong. If one looks very practically to the way in which judges are appointed in South Africa, if one looks at the work of the Judicial Service Commission, precisely the opposite is clearly evident. The present Chief Justice is on record to have said, already back in 2013, when there was a huge debate, a huge dispute actually, on the appointment of judges and specifically of the role of Judicial Service Commission, he said that there is no need to appoint the best of the best to the bench. And secondly, he said, merit is not the only requirement. And he said that against the background of a strong argument that he vigorously pursued, namely to promote transformationism, representativity, racial representativity, and specifically identifying so-called transformation candidates to be appointed to the bench. Who are these transformation candidates? They are people that can be trusted as subscribing faithfully to the ideology of transformation.
As the disciples,
so you can't trust on that.
Yeah, so the disciples of transformation,
yes.
They need to be there. What is odd, I agree with everything you say, knowing a little bit about how the system works. What is interesting to me is that there's a core fallacy, which is the noble savage fallacy, right? That pre-colonial Africa was this wonderful place of abundance and things like that. So the ANC loves that myth, and then it wants to use the constitution that it imposed on us to go back physically to that myth through transformation. Yeah. Basically, Africa for Africans and everything was perfect. Yeah. And we whiteys came along and destroyed all that, and now we need to reverse that. But the Constitution itself is a import from Canada, basically, as far as I understand. So they're willing to use foreign legal instruments to get back to their noble savage myth. It's curious. Yeah, but useful.
Yeah, I fully agree with you. But just coming back to propaganda, you used the word propaganda. I would suggest a little amendment to that. It's not propaganda; it's religion. Nowadays, it has become a very important research focus to look at constitutions from a specifically religious point of view. Carl Schmitt, German theorist in the 1920s, 1930s, and so on, who has become very prominent now in the 1980s and so on, in the 1990s, and also at present. He's actually the first person who has emphasized the point that when you deal with constitutions, you are dealing with religious phenomena. Now leave him there. And if I may refer to the book in which I dealt with the question of the Supreme Constitution, just look at the words, at the terminology that is being employed around the Constitution. We have a supreme Constitution. That already is a word which is religiously charged, I would say, supreme. The rights are guaranteed. The rights are entrenched. As a matter of fact, the rights are enshrined. In section 2 of the Constitution, it is stated almost as a fact that this Constitution is supreme, and everything that's being done must comply with the Constitution, almost as if it's an established fact, completely deviating from what any legal document is. A legal document is normally a set of norms, right, a set of norm formulations that it can be adhered to, or it can be simply disobeyed,
dismissed. But importantly, it must be up for interpretation.
Exactly.
That's the essence of what law is.
Exactly. Right. Exactly.
Because on page 31, you list the 9 essential beliefs of statist-individual constitutionalism. And number 4, extraordinary faith in the written word.
Exactly. Exactly. I'm very glad that you actually remind me of that, because the whole constitutional discourse, both the Constitution itself, as well as the high priests of the South African Constitution, but also the high priests of the United States Constitution. And by the way, those 2 people that I've referred to at Yale, I don't think they fall within that category, because they are people who are critical of that. But these high priests, with due respect, some of them are my colleagues. They, in a sense, are inculcators of the wonderful, august notion of the Supreme Constitution, as if it has a fixed meaning, and if it can serve almost in a very godlike fashion as our protector, like a god. This is part and parcel. Our entire legal discourse is permeated with those ideas and with terminology which is in step with that.
That's very true. That's very true, actually. You ask,
and I think it's very important that also people within constitutional law, which is actually the very cradle of that religion, of that false religion, should actually be brave enough and open-minded enough to point that out. Because if you don't do it, you might run the risk of investing your trust in something which is presented as the final protector, which eventually might turn out not to be the case.
So, yes, I actually going to put my notes away, because this is going to somewhere where I haven't made notes for. So I tend to agree with you. A few years ago, one could say that I was obsessed by evidence. Right. If there was evidence for something, I believed it. I listened to the New Atheist at the time. I listened to Sam Harris at the time, Richard Dawkins, evolution. Scientism matters. Science matters a lot. If there's evidence for something, it must be true, and you cannot really deviate from that truthfulness of it. Then I started reading marketing, and specifically a chap called Rory Sutherland, who's based in England. And he wrote a wonderful book called Alchemy. It came out last year or the year before. And he quotes various economists, philosophers, especially the Austrian School of Economics. And you come across praxeology, where what is economics? It's human action. It's whatever humans determine to be economic activity that becomes economic activity, and value is subjective. And we actually create a lot of these things from our own minds. And then when we share those ideas with others, they value the same things too. So the Constitution in South Africa is actually a form of value imposed from above. And if you deviate from seeing it as valuable, you're seen as an apologist for the past, or not progressive enough, or a segregationist perhaps, things like that. But essentially, law and order is basically a community forming norms over time, and then maybe or maybe not codifying them. But it doesn't have to make sense to work. It can just work. Whereas a constitution needs to make a lot of sense, and it still doesn't work.
Yes. and its claims prove themselves to be unfounded. One of the fundamental things we briefly refer to that, and all of us know about that the Constitution claims to be supreme, and in that sense it claims to be durable. It cannot easily be amended. Okay?
Yes.
And to the extent that it is not amended, we tend to assume that it still remains the same. It still has the same content. That's the writtenness, the trust in the written word. That is entirely not true. If one looks at some of the most important values encapsulated in Section 1 of the Constitution, you come across very interesting things. Interesting things because they are almost out of this world, so to say. For example, we adhere to the value of non-racialism. Now, I do not adhere to that. I think, and people might disagree, we have different identities. And it's not to say that those identities are necessarily fixed. Neither does it say that you only have a single identity. But the question of race is a fact. You know, we deal with that in South Africa every day. But the notion of non-racialism says that the race is not a factor at all. It shouldn't play a role within the public sphere at all. We're only just individual people.
Yes.
Okay.
Well, that's the ideal.
Yes, it's the ideal.
Yeah.
In contrast to the idea of multiracialism and the recognition of a number of cultures which recognize the fact that there are a multitude of cultures, races, and so on. Which is not to say that you can exactly define them, but that doesn't matter. Because most things that we're dealing with in social science and in history are not susceptible to proper definition. That does not mean that they are not there. So what has happened is that Section 1 of the Constitution, the fundamental foundational values, are even, to use the August words of the Constitution, more heavily entrenched than the rest of the Constitution. They can only be amended through a 3/4 majority of Parliament. I think one can put it as an established fact that the notion of non-racialism has simply disappeared. It is not a value of the present South African constitutional order, neither is it striven for anymore.
And the high priests have not fought for it at all.
Not at all.
On the contrary.
Not at all. On the contrary, precisely, with the Constitutional Court playing its role, and obviously the other very august institution, the Human Rights Commission, okay, which actually was one of the front runners of the idea of a very nasty multiracialism, okay, where the races are actually put against each other instead of protecting, well, at least trying to protect good relations among various groupings. They actually went for the opposite. So what happened? The constitutional text has remained the same. It makes the misrepresentation that no change has taken place. In actual fact, something that requires a 3/4 of majority has changed completely. So you can't ask the lawyers in that regard, especially the constitutional lawyers. And with respect to Professor De Vos, you can't ask Professor De Vos what the Constitution says in this regard, because with respect to Professor De Vos, since he adheres to the idea of the supreme constitution, writtenness, and so on, he might run the risk, I think that's what will happen, that he will make a misrepresentation. He will deceive himself to tell you and himself that the Constitution still adheres to the idea, still subscribes to non-racialism, which actually is history. It has simply fallen by the wayside.
Yeah, it appears that is it the Equality Clause, Section 36, I believe?
That's Section 9.
Section 9, where it says discrimination is always wrong except when it's fair. What's that
a little
clause?
bit different, but that's basically what it boils down to.
But that clause
it's only an unfair discrimination which is prohibited.
Yes.
But you know...
But fair discrimination is fine. But that clause has been elevated above Section 1.
Absolutely, but there's also something else. And it's good that you raised that point. There's something else that we have to emphasize when it comes to Section 6, Section 9, the Equality Clause, something relating to the point that you've made about the kind of paradisical condition that was prevalent before the arrival of Europeans in South Africa. That is that in a sense the equality clause has been marginalized. Something else has come in its place. And that is the idea of representativity. And the idea of representativity in a nutshell means that each and every organized institution, public, private, civil society, and so on, must be representative of the population profile of South Africa as a whole. And the people in charge of that must also see to it that the right policies and the right ideology is properly enforced. So that's nothing else than a very blatant totalitarian policy, which strangely enough is channelized through the equality clause.
Right.
One would have thought that equality would serve as a
break,
as a kind of a sally against the idea of the totalitarian state. Not so. Very interesting. Through interpretation being done by the ANC and with the Constitutional Court in step, exactly the opposite has happened.
Indeed, the Constitution becomes a conduit to totalitarianism.
Exactly. I think that's the most important thing actually to mention. You know, the idea was, the assumption, the belief once again, was that let's enter into a so-called social contract. Poor Mr. F.W. de Klerk, I read in the weekend's newspapers, also made that assumption. We made an agreement. The agreement is encapsulated in the Constitution, and in that way, ideologies, regardless of whose ideologies it might be, are actually brought to an end, brought to a standstill. From now on, there's the one truth word, the gospel encapsulated in the Constitution, and we adhere to that. That's nonsense.
Goodness, Professor, we heard that argument in 1991 from a Mr. Fukuyama. The end of history has arrived.
Fukuyama was entirely wrong,
but not catastrophically.
Catastrophically
and so
wrong.
Was Mr. de Klerk in this stage.
But by the way, that's not a new thing. The end of history has been announced through history on various occasions.
Indeed,
you know?
Indeed.
Just for the announcers to realize that history has very forcefully re-emerged again, and this is what has happened over the whole Western world and also here in South Africa. What happens in South Africa is specifically that the Constitution. I can't improve on what you have said, but the Constitution simply is an instrument which through interpretation, with which you can do almost anything,
yes,
which through interpretation is used, I don't want to say abused, because that's normally what happens with interpretation, which is simply used as a political strategy to achieve the original goals of the, put it in bracket, in inverted commas, the revolutionaries, to achieve the National Democratic Revolution, transformationism, or whatever is the correct term.
But they're not even trying to hide that fact. I mean, it's not a conspiracy. We've been talking about the National Democratic Revolution on the show for 4 years now, and last year, people are finally starting to say, oh, that makes sense.
Yeah.
With expropriated like compensation was the most stark reminder of the fact. But I mean, the ANC have been very open with what they wish to achieve, and they've been very open for 60 years. They don't hide in the cupboards. They're not reds under the bed. They walk up to you as a standing. You see them coming from miles away.
I think the very first time it was very expressly articulated in ANC working documents was back in 1969.
That's correct.
And since that time, it has been repeated times without number, and is now part of practical policy. Okay, what is actually very disturbing is that many people that we actually expect to know better have simply decided it's not worthwhile taking notice of that. Apparently, in the assumption that the Constitution will actually supersede all that.
Exactly, and that's the irony. So you have a lot of people who adore the Constitution, treat it like a faith-based instrument. Yes. And when the executive or the legislature or someone does something wrong, they say, oh, not to worry, the Constitution will save us. And this is a common tactic by analysts and journalists and things like that. So, well, that was wrong according to the Constitution, so the Constitutional Court will come out and say it's wrong, and then we'll be back at day zero. And this happened when the Constitutional Court told President Zuma that he must pay back the money on his Nkandla homestead, but also that the powers of the public protector are also supreme and they can only be dismissed with a court order. But also, Judge Mogoeng said, this court is vitally independent and we will absolutely strive to be independent from the executive and the legislature and parliament and all the rest of it. But when you look at the ideology of the judgments that come from the Constitutional Court, it's in step, in line, on the coattails of the NDR straight away. So there's a facade of independence throughout this facade, let's call it what it is. But they're all working together under the assumption that they're all independent. People fall for it. People should know that. Journalists,
exactly.
law professors, not you, but they do fall for it.
It's so bad that specifically also, perhaps one can excuse the poor law professors for that because we have to believe in holy scriptures, But journalists deal with politics, I actually blame them even more. You see, if one goes into a little bit of history, various constitutional court, and these things are very important, various constitutional court judges and very people with a very high what's the word I'm looking for? People that were academically very highly regarded, truly as kind of truly academic judges, intellectual judges. People such as Moseneke, is on record very explicitly. I've discussed it there in chapter 7 of the book, to have said back in 2005 already that judges, together with the entire society, must unfailingly promote the ideas of transformationism, of transformation. Namely, the ideas that I've mentioned, to inculcate and promote a totalitarian society in South Africa, a totalitarian state. If you break down what he said, this is exactly what he actually requires of judges that have to think in a new way. Now, when he said that, he was in step with a variety of American scholars, leftist American scholars who were extremely inspired by what happened in 1994 in South Africa. They thought a wonderful socialist state would be dawning upon South Africa, and a number of them flocked to South Africa. There's still some of them at the University of Witwatersrand. Let me not mention the names now. Good friends of mine.
That's where I'm from. I don't know who you're talking about.
Yeah, obviously you won't know. So Moseneke is on record to have said that. Now, this is actually very important. People would say, well, but transformation is a good thing. That is, you can only say that if you don't know what it is. Transformation is simply another name, a more acceptable name for the moment, for old leftist ideology that has been promoted in the Soviet Union, obviously in a bloody way and so on. Yes. But in a nutshell, in as far as content is concerned, it's still the same thing. So you cannot excuse totalitarian policies and totalitarian ideology on the basis that your totalitarianism is a good one.
Kinda.
You have to reject it as such because it flies in the face of the idea of individual freedom and of freedom of a variety of communities.
Right.
Now, he's on record to have done that. And what the Constitutional Court has done since then is to follow through with that. And let me just say this. You mentioned the point. I'm glad that you mentioned it. You can distinguish between two sets of cases. Two sets of cases decided by the Constitutional Court. Once there are cases which has to do with what I call, it's not a term that I developed, I got it from other people who research these things. When you deal with an internal hiccup within the ruling elite, such as the Nkandla case,
right.
Most of the people within the ANC were already at that stage against Zuma. Okay, so what the Constitutional Court simply did was to restore the balance within the ruling elite And as a result of that, it ruled against Zuma. It was also easy for the Constitutional Court to do so because the balance at that stage had already swung against Zuma.
Yeah, and he had very little public popularity.
Precisely.
Yeah, it was 2016. He was out the year after.
Yes.
Or 18 months later.
He was yesterday's hero already.
Yes.
Just another case. The Sasa case on the social grants.
Yes, Batapile Dlamini.
Exactly.
Yes.
There the Constitutional Court apparently, seemingly very boldly, took stance against government. On the basis of what? Well, read the first paragraph of the judgment where Vroneman said, one of the basic commitments of the present constitutional order is the socialist idea, he didn't use the word socialist, but is the idea of promoting equality through these social democratic means of socio-economic rights.
Right.
So what the court actually did through that was to bring, through its judgment, was to bring the ANC back to its initial points of departure. That's what happened.
Yes.
So it was not the court that ideologically ruled against the ANC. It was the court stabilizing the ANC.
I know it was a crying shame because I was hoping that Batapile Dlamini would stop paying social grants and then the whole edifice would fall over. That would be great. But the court came just in time to make sure that the edifice didn't fall over.
Exactly. Let me just say this. I won't go into the detail, but I can mention at least 6, 7 other cases, but I would, if I can abuse this opportunity, say I would like to invite the people to read the book and to have a look at chapter 7 specifically, where the ideological cases are in fact discussed. And you can predict the Constitutional Court that whenever an ideological case arises, whenever any strand, any aspect of transformationism is possibly challenged, the Constitutional Court is bound to give a very forceful judgment against that institution, that party, who is regarded as the challenger. The language cases, Free State University language case, Stellenbosch University language case, the Pretoria street name case, the Agri-SA case on mineral rights, the Glenister 3 case, in which a lot of evidence was sought to be adduced, indicating that the Hawks could not resort under the police because the police is a corrupt institution, under the control of a corrupt executive, under the control of a corrupt ANC. There was sufficient evidence to that end. The Constitutional Court rejected all that evidence under the cloak of rules of law of evidence. Okay? Mm-hmm. In actual fact, what happened there is that the Constitutional Court simply sought to protect the historical take of the ANC of itself being the collective hero. Once it would have allowed that evidence, that whole idea of the ANC as this collective hero, this savior almost.
The liberators, of the country.
Would have been gone. Now, the interest. So that was a pure ideological judgment. It was about the interpretation of history. Just by the way, one of the judges who was involved in the majority judgment in that case was Mr. Justice Zondo. At the moment he is the chair of the Zondo Commission, now he has to listen to 1,000 as much times to such evidence. But those are all those cases, and to that one can add a number. All those cases are cases that are somehow related to the ideological assumptions of the ANC. And in that case, the Constitutional Court, that's very important, being an ingredient, a role player, one of the parts of the ruling elite, can be predicted, as it has done on numerous occasions before, to give judgment in order to protect the ideology.
That's an essential ingredient of the NDR, in essence, is your argument. But Professor, what is actually going on here? I mean, do you think there are real ideologues at the head of the judiciary that are actively promoting this? Or do they look at the Constitution, interpret it in the way that they think it needs to be interpreted, and then make judgments based on that? I mean, do you think there are how can I explain? Is it ignorance? Is it intention? I know we can't go psychologically into these people, and I'm not asking you to do that.
Yeah.
But do you think that this is a play at hand, or is it just a consequence of the ANC hegemony?
That's a consequence precisely of that, of hegemony. Precisely also as a result of that, and I think that is, we can discuss that. I would also like to hear what you say about it.
Sure.
I think a characteristic of a hegemonic order is that things are being done almost automatically. The one subscribing and giving effect, articulating the ideology, is to such an extent anchored in that ideology, he or she is not even aware of that. He or she thinks that he's just speaking some kind of objective truth.
Yes.
So I think what has happened is over the past, 25 years, 26 years, even more, going back to the period before 1994, an ideological consensus has come about already within what I call the dominant elite, which after 1994, obviously very importantly, include our universities, our university managements. We can say something about that. The public service, the police, the army, the courts, and so on, in keeping with what the ANC wanted to achieve. That's what they say repeatedly in their documents. So all of them form part of this hegemonic ideology and play their part in achieving that.
Yes.
So it happens automatically, but still by design.
Right. I read a book, and I think you're correct in that way, a book called Ordinary Men by Chris Browning, who's an historian, who documented the case of police reservists who were Nazis, and he managed to he terms, liquidate hundreds of thousands of Jews in Poland from 1941 to 1944. But these were professionals or the working class. They were plumbers, accountants, lawyers, and the rest. Reservist force, so they weren't forced to be there.
Yeah.
And they were designated to enter villages in Poland, find out who the Jews were, take them to concentration camps or kill them on site. And he just states that after a while, these people just became so inculcated in the ideology of the Nazi party. And not necessarily the ideology as such, it just became the way of life.
The new normality.
It was, he calls it functionalism. The function of the system, you just inherently become a cog within it. You don't necessarily disagree with it, you don't agree with it, it's just it's like as automatic as us brushing our teeth. It became automatic for them to put their rifles at the back of a little kid's head and shoot him in the head. A little Jewish child and shoot him in the head. It just became inconsequential at the end of the day. And I think that sort of functionalism is happening
most definitely
in South Africa. But also, we're not just talking about but generally in any state, so to speak. That's what we just talking about South Africa because A, it's dangerous, the NDR, and B, because we live here, right? So we need to be aware of it. But it's not inherent to the ANC. They're not this wonderful, all-powerful states.
Exactly.
Everyone else does it.
Adding on to what you've said there, because I think it fits in perfectly here. Many times you would get people saying, no, the Constitutional Court has given the wrong judgment. The interpretation of the Constitution was wrong. As a law student, most certainly you've heard it in many cases. No, in this particular case, this minority judgment in whatever, a law of evidence matter or whatever, minority judgment was the right one. The majority judgment is the wrong one. In a sense, there's no right and wrong judgments, in a sense.
Yes.
In a sense, it's all a question of interpretation. And specifically when you're dealing with things that have an ideological flavor, then obviously you don't have a right and a wrong. You have something that ideologically makes sense and something that ideologically does not make sense, depending on the specific ideology. So I'm not saying that Mogoeng is that bad a judge. I don't think, by the way, that he's a good judge. But the point is that many of the judges who sit there on the bench of the Constitutional Court might be good jurists. And many of the people arguing the cases for the ANC, or for government, or for the University of Stellenbosch, or whatever, might be good jurists. But the people arguing, presenting counter arguments might be as good jurists.
Yes.
Okay? So it is not the point of the validity, some kind of objective validity of an argument. It is which argument is in keeping with the hegemonic views of a particular, at a particular stage. That will eventually carry the day. What then happened, and I think this is a very important point to make, we say, in step with Max Weber, that the state symbolizes the monopoly of power and of violence.
Yes.
I agree with that. That sociological, very realistic view of the state is spot on. What one tends to forget is that the power of the state vests in a number of institutions, also in the court. And once the court has given a judgment, so at least the theory goes, it's final.
Yes.
So the court shares in the monopoly of violence. So when it gives judgment against a particular grouping, it actually commits a form of decisive violence that may not be gainsaid because it has the flavor of legitimacy and constitutionality. So it's a very blatant form of violence committed by courts, including by the South African Constitutional Court.
Right. But I agree with you, but people would say yes to your argument if you apply it to the National Party.
Yes.
Or to the segregation laws in the US, or to the Khmer Rouge, or to the Soviet Union. They would say yes, but those courts are all illegitimate. But the same thing's happening here.
Yeah.
It just has a veneer of respectability
Yes.
and authority. But it's exactly the same sort of phenomenon.
Exactly the same sort of
right?
phenomenon. You see, that brings up a point which relates to this whole question to your very first question, statist-individualist constitutionalism. We say, no, we strive to achieve a justice, and the most important ingredients for achieving that is through the state and its various institutions, and through the protection of individual rights by the courts. Over and above that, there's no need for anything else. That is not so. This is only one form of constitutionalism, namely what I tried to discuss in the book, Statist-Individualist Constitutions.
And a very recent form.
A very recent
of constitutionalism.
Form. A very recent form.
I think you've elucidated about what the problem is, and you've certainly rattled my intuitions. Because, Professor, I don't know if you're aware. You must be aware. You're in academia. Talking about this in polite and impolite company is very controversial for some reason. People don't like to hear the holes in their fabric of reality that they've envelop themselves in. They don't like it when you poke a hole in their fabric of reality. So before you go to the potential solutions to the problem that you've eloquently put up, what has your faculty, if I may, your students, the general academic demeanor around you, what has it been when you make these sort of arguments to them?
Yeah, I don't have any serious problems of relations with my students, neither postgraduate or undergraduate. I get along with the students very well, and I raise these questions in postgraduate classes, in undergraduate classes, all over. I think that might sound like a very, very august claim. I think that is the job of an academic. That's a job of a true intellectual. And there are many more intellectuals much better than me. I can mention some in my immediate circle. But that is what you have to do. That is the difference, with all due respect to teachers and an academic. You must be able to question the accepted hegemonic thinking. You must be able to actually do that. And good students, 18-year and 19-year and 20-year-olds too, not only postgraduate students, have a feel for that. They do have.
Yes.
And that's actually my experience. So I have a very pleasant experience of students across the board. I'm an Afrikaner, and I'm an articulate Afrikaner, but Afrikaans-speaking students, black students, and so on. My experience with all of them is actually fairly positive. Not fairly, it's actually very positive when one raises these questions. And as a matter of fact, my feedback is that students, even though they might strongly disagree with you, want these questions to be raised. It's interesting.
Oh, very good. No, but I think it's vitally important for students to be aware that there are arguments against what they believe. I mean, that's the essence of going to university to study something. You know.
As to colleagues, this research that I've done, which is included in this latest book, would not have been possible without the work of many other colleagues over a period of 100 years. Okay, person who's died 100 years ago is certainly not one of your colleagues, but following on Burke, it's one of your colleagues. Inside South Africa and also obviously outside South Africa, because we are in the final analysis a very small province in the larger intellectual world. So yes, there are many people who actually not agree with me, people that I agree with, whom I can make use of, and upon whom I have drawn for producing my work, and hopefully there will be much more to follow.
So I actually want to, before we get to the solutions, sorry, just very quickly, I've noticed that you refer a lot to academics and thinkers in Europe, namely Brussels, Holland. Do you have a special relationship with academics in those, particularly those two countries?
Yeah, I do have good relations with people in Belgium and in the Netherlands. But I also do have, not on a personal basis, but good relations also with people in the United States. I think in the final analysis, the degree of having been influenced is actually more from the English world than the European world. Yeah, but people that I know directly are more people in Western Europe. Okay,
and they seem to like your book. Well, especially on the back here, professor of Leiden University in the Netherlands and Martin Brassey, and in the University of Brussels. Yeah. It's just interesting. I wonder how your book, if it was ever released in the US, how they would see it. Because a lot of the arguments you make can be used against the US Constitution, which a lot of people, even me, think it's quite a good thing, the US Constitution, generally speaking. Yeah. It was the smallest government with the most liberty, but now obviously. Yeah. Well, may I just say, a lot of the research on the question of, is the Constitution really supreme? Can we really trust upon the claims of the supremacy of the Constitution? Many of the questions relating to individual rights, to questions of impartiality of judiciary, has been done in the United States, actually more so than in the United Kingdom and in Europe. And to that extent, well, I owe a lot to the Americans. There's one person whose name I would like actually to mention. It's Professor Bruce Ackerman of Yale University. I've been profoundly influenced by him. I had the privilege of to have met him 10 years ago. He's a very flamboyant person. He's now 77 years of age and so on. 77 years old. He's a very profound academic, and he certainly has influenced me. So yes, and there are also a couple of other Americans. One interesting thing about the Americans, it's not difficult to just say, well, the Americans are so and so. Yes. That society is just too big and too interesting. Of course. But what is interesting about them, and it's because their constitution did not allow for it, the First Amendment, I think, is possibly one of the greatest things that have happened to humanity, generally speaking, because the sense of inquiry you get from an American content creator or academic, or it's just it eclipses most of the world. Yeah. I mean, just the amount of choice in terms of the ideas, the so-called allowable ideas, it's just immense. Yeah, in the US. Absolutely. And it's probably thanks to the First Amendment, because the Constitution did not include that first. But anyway, Professor, just lastly, so you've shot a hole right through the Constitution as the holy book of legal jurisprudence in the country. What are you proposing otherwise? Are you saying that South Africa is a nation of a state of different nations, and these different nations must develop their own constitutions? Well, the whole idea of a South African nation is just nonsensical. There is not something like that. There is a South African state,
shivering, debilitated South African state. We know that. I think the point of departure, I would say, would be twofold. All the institutions that we regard as institutions responsible for checks and balances, none of them actually in South Africa serve that particular purpose. They are all, and that's a word that I use much in the last chapter, they are all state departmentalized.
Yes.
The universities are state departmentalized. In the sense that they are nothing but actually state departments. The rectors, with all due respect, are director generals. The professions, also the legal profession, unfortunately, which is supposed to be as independent as possible, has been state departmentalized as a result of this transformationist ideology. And at the moment, as a result of legislation that was passed 2 years ago, this is exactly what has been happening with the legal profession. And so one can go through entire society. So the point is, the checks and balances, which have to be anchored in a large variety of institutions, each with its own power and influence, that has to a large extent been damaged in South Africa as a result of this, as I've said, state departmentalization, which is a function, a consequence of the transformationist policy. So that's the first thing. One must try to conceive of institutions which can, in fact, serve as true checks and balances, true centers of power that can say no to government, and that can represent the legitimate interests of a wide variety of communities within society, be it cultural, linguistic, religious communities, and be it universities, be it the professions, and so on and so forth. So that's the first thing. The second thing is this: it's a profound misconception that individual rights represent the basis of checks and balances. All of us are very dependent upon individual rights. As the two of us are sitting here, we are individuals and we cherish that.
Yes.
And we should do so. But in the final analysis, we are very weak when we have to stand against the state. And you are only strengthened when you are part of an organization, part of an organized civil society. And in the final analysis, part of an organized community. The backbone of checks and balances in the final analysis are a variety of communities with its own ability of self-management, its own property, very important, and its own ability of self-management. So it's, in the final analysis, therefore, it's not only a question of the recognition of individual rights, it's a question of taking up power. That's very important. In our present constitutional discourse, everything seems to be about rights.
Right.
I exaggerate a little bit, but in a sense, rights is secondary. In the Constitution, the division, the separation, but not only separation, the division, the diffusion of power, in order to see to it that no center of power has enough power, has sufficient power to actually eventually bring about some kind of totalitarianism. That is the most important thing, the diffusion of power. And that is, in fact, to use the power again, within our power.
Understood.
We can actually achieve that. Fortunately in South Africa, we have a large number of community institutions, which in the past couple of years have grown quite strong, and which is actually serving as the backbone of checks and balances, and which are also achieving an increasing amount of self-management, even self-government power. This is actually happening in South Africa. It happens as a result of two reasons. Firstly, because I think people realize that that is to be done. And secondly, it happens in consequence of, and one can even say, thanks to a failing state.
Absolutely.
Because that creates the opportunities for people actually organize themselves on a community basis, on a territorial basis, and so on and so forth, and simply taking over as a result of a retreating state a large number of powers which incorrectly would have been associated with typical state powers, which
Yes.
we simply take over as a result of the fact that we don't have any choice and we realize that actually we can do it better.
So I fully agree with you. I'm a big fan of Dr. Franz Cronier and his 4 scenarios. And I think the 4th one, which is sort of the balkanization of South Africa, is probably the one that will happen and the one that I would prefer, if I'm honest, because I think community power is absolutely essential. Unless you live in Cape Town where you think this is Monaco, but this is Africa, and power is important in Africa.
Yeah. Or unless you live somewhere in the Constitution, you know.
But in a material way, I'm sorry, Professor, if I'm keeping you. In a material way, what can people... Are you asking people not to use the courts as a handbrake on the state? Because essentially, the whole conversation that precedes this question states that the courts could be a conduit to what you don't want.
Yeah.
So are you saying ignore courts completely? I mean, obviously, or you can use them strategically. What is the role of the judiciary in making sure that we keep the power with us as communities?
I think it's just important to conceive, to have a realistic notion of what courts can do, what courts traditionally can do. Actually, one must put the courts in their place. If you are involved in a car accident and if you appear in front of a magistrate, be it a man or a woman or a black man or a white man, doesn't matter, most probably you're going to get a good judgment. Okay?
Yes.
And so it can continue with private law cases, with commercial law cases, and so on and so forth, with criminal law matters and so on. I think by and large, you can still expect good judgment, good litigation leading to good judgments. That's the traditional role of the courts.
It's fraying a little bit in terms of criminal, but yes.
Very, very important actually. And fortunately in South Africa, we still have a large number, we do have a large number of well-trained lawyers in legal practice. They also know how to deal with the magistrates and with the judges, and they, in a sense, serve as a check and the balance. One should take that into account.
Absolutely.
That's the role of the courts. But when it comes to the protection of communal assets, okay, of things such as language, religion, but also physical protection, okay, when it comes to a lot of functions and responsibilities traditionally identified with the state, identified with municipal government and even national government, there's no need or there's no basis for trusting upon the courts to do anything about that. Most probably will get a judgment on it, a favorable judgment. But your judgment will turn out not to be a judgment and not to be an order, but a wish. Because the court, the state simply doesn't want to do anything about it, or even worse, is incapable of doing something about it. So the right thing to do in that case is simply to cultivate and develop the strength, the power, the ability on communal basis, taking into account the failing of the South African state and realizing that in order to do something about that, there's no sense in pleading to the state to do something that it's incapable of doing. The point is organize oneself on a communal basis and simply take over, simply usurp in a sense, simply, let me put it in a different way, simply respond positively to the state's implicit invitation to take over the powers it simply is not capable of discharging. That is what we have to do. So basically, I agree with Frans Cronje, and I say, let's not stand back from it. As a matter of fact, that's a wonderful opportunity that one has to seize.
Absolutely.
Now, there might be people who will say, well, this is entirely against the Constitution, and so on and so forth.
Treasonous.
That is, in a sense, against the idea of an organized society. No, that is not so. And this is very important to me. What comes in the place? What is a substitute of a legal order that falls apart? Is it chaos? I say no. I say no. What comes in the place of that is default law, a default order, which is created by you and by me and by active members of society organizing themselves in their various communities and cooperating with one another. In that way, what is actually happening, a new constitutional order, not necessarily countrywide, but in many places, are actually coming about. So in the final analysis, it boils down to the fact that instead of trying to write a new constitution, what is actually happening in South Africa is that we are building one. We are simply building one through the various actions and activities and enterprises, civic enterprises, and so on and so forth, which we're involved in.
What a magnificent conclusion. Professor Koos Malan, thank you very much, sir. What
Thank
an
you.
absolute pleasure to have you on. I would love to have you back.
Thank you. My great pleasure to have been here.
For those who are watching, his book, There Is No Supreme Constitution, I think that was the best advert you could have heard for buying it. And I assume it's available in most bookstores. It's available on Kindle, I know that.
It is available on Kindle, yes, and on most outlets such as Google Books, Take a lot, and
yes.
so on and so forth.
Okay.
Also available in most bookshops of most branches of Protea Bookshop.
Protea Bookshop. All right. Well, Professor, where can people find you if they want to look you up? You're not on Twitter, I assume.
I'm not entirely illiterate when it comes to social media, but I'm not on Twitter. But I can give my email address, no problem.
All
Shall
right.
I give it? It's
You can, sure, you can spell it out. We'll put it in the show notes as well.
yeah, okay. It's Koos. Everyone knows the Afrikaans name, Koos. KWS.Malan, MALAN @UP, University of Pretoria.ac.za.
Fantastic. And once again, Professor, this has been magnificent. My favorite conversation in a long time. And thank you very much for all that you do.
My great pleasure. Thank you.
If you're still watching, thank you so much. We will see you next time.